Well, let's go straight into the conversation. Joining us all the way from Lagos is legal practitioner, barrister Mike Umunan. Thank you so much for being on Politics Now. Now, you've seen how the Supreme Court's verdict has gone by with all the reactions that has followed. All the governors retained their mandate. Talk to us. What are your thoughts on this?
My brother, you see, the Supreme Court, apart from the issue canvassing or ruling on the issues of law and facts, the court is also a policy court. It takes a lot of things into consideration in reaching the judgments, as it were. What is going to be the reaction of the system after the judgment? How would the people react to the judgment? These are some of the issues that the court, the Supreme Court in particular, takes into consideration because of the policy aspects of its function in giving judgment. And so that I was not surprised to see that the judgment of the tribunal and the Court of Appeal in respect of Kano were upturned. And then the same thing with the judgment of the Court of Appeal in the Plateau State. Because like Kano now, we know the very delicate nature of Kano politics. And that I'm not trying to be looked down on, but so many of the followers or the voters in Kano look up to a particular figure as their mentor, as somebody they need to follow. And so once there is a deviation, maybe even the election umpire like INEC, there will be problem. And so once it was decided that Abba Yusuf was the governor from NNPP, I saw it as a very difficult thing for anybody to upturn that decision, bearing in mind the volatile nature.
Also with us on the show is public affairs analyst Jide Ojo. Thank you so much for being with us. Just to get your quick reactions to the verdicts from the Supreme Court on Friday regarding the governorship election petition cases.
The judiciary is an independent arm of government, peopled by human beings who are prone to making their own mistakes. They are not infallible, and whatsoever dissatisfaction we have had with the judgment of that arm of government have to be abided with. And I cited the example of the executive arm and many of their dissatisfactory policies and programs, which has led to mass protests, including from labor unions. Even the legislative arm has not been satisfactory. That's why you see a number of times Nigerian media and civil society will march on the National Assembly, asking them to do one thing or the other. Now, the Supreme Court decision in 8 states, 8 governorship election of last Friday, 13th of January 2024, is a calming ban, because I really don't know if there would not have been breakdown of law and order in at least 2 to 3 states arising from the judgment of the Court of Appeal. One is Zamfara, the other is Kano, and the third one is Plateau State. Very unfortunately, the Plateau State stands out like a sore thumb, particularly given the miscarriage of justice by the Court of Appeal in sacking 16 State House of Assembly members of PDP, 4 House of Reps members of PDP, and 2 senators of PDP. If the Court of Appeal had been discretion, if they had followed the already established law by the Supreme Court, I believe this collateral damage that we have seen with PDP in Plateau may not have happened. One of the newspapers this day reported today that the PDP National Working Committee had petitioned the National Judicial Council and Judicial Service Commission over the miscarriage of justice that took place in Plateau last November.
Now, let me get back to Barrister Mike Umona. The decision of the Supreme Court in Kano and in Plateau State, was it swayed by the tension in these particular states? Because that's one allegation that is, going round the polity.
Very well. That is why I'm saying that the Supreme Court is a policy court. It takes a lot of things into consideration. It takes a lot of factors into consideration. When they gave the judgment in respect of the presidential election, because they were trying to protect the nation from going into serious crisis, because of the fact that the president had already been sworn in, I said it that the Supreme Court, because of being a policy court, would not want to upturn the situation, would not want to upset the situation, would not want to change what is going on in the situation. It is when they look at the law and the fact, and then the nature of the place, the society, that they now give decision to ensure that we still have stability. So I can assure you that the nature of these states weighed more than even the law and the facts before the court, when the court gave the judgment. I did not expect the court to upturn, to upturn the decision of the people, or to support or to oppose the decision of the Court of Appeal in respect of Kano. Same thing with Plateau State. We call that on this platform, I said it that the decision of the Court of Appeal in respect of the Plateau State was an unfortunate situation, because you cannot talk about structure, you cannot talk about when these people had already won the pre-election issues that should be determined not by the tribunal, but by the court before the election. Not that you wait after the election, you have 40 days to do that. Then after the election, you now bring that issue to the tribunal. You would have known that you are time bound already. So there is limitation of time in respect of that. And so that is why it becomes difficult for anybody to come and canvass the issue of the pre-election issues before the tribunal and succeed. And so I said that I did not see a situation that the decision of the Court of Appeal in respect of the Plateau State was going to stand. You understand? Apart from the fact that although this is politics, it is possible for all the members of the House of Assembly to move from PDP to APC overnight, like what we see virtually all the members, what we see in Rivers State and all of that. It takes a lot of effort to see that the majority of the people or the majority of the politicians are in a particular political party, and you now hand over the mandate of the people to another person. Although I have been against the issues of saying that the court should be the one to decide issues concerning election. Election is something that is supposed to be decided by the people. And so once the people make up their decision and it is genuine, it is seen to be just, not that the people decided on a particular candidate, and then INEC decide to announce another candidate. Once the people, the majority of the people make a decision, it should be allowed to stand. The court should not dabble into it. The court should not upturn it. And that is why I believe that the Supreme Court did the right thing by not upturning the decision of the people and then supporting the Court of Appeal in respect of the Plateau State.
Mr. Umunan, the particular issue that is, hitting the conversation in the country has to do with the fact that Nigerians are not happy about the case of the 11 lawmakers in Plateau State that were dismissed. And now the Supreme Court ruled in their favor, but they can't be remedied because the parliamentary elections ends at the Court of Appeal. Now, meanwhile, the secretary of the People's Democratic Party, PDP, has said that they're going to press forward for a judicial review of the court's judgments at the Court of Appeal in our Plateau State. I want to know your candid opinion about this dilemma, that is facing us as a nation with regards to these lawmakers who were sacked by the Court of Appeal in Plateau State.
Yes, that is another area that we, at the moment, there's nothing we can do about it until the law is amended. The law is amended so that these kind of cases can get to the Supreme Court that has the power to also rule on the policy aspect of the situation of the society. And it was a very unfortunate situation when I read all those issues concerning those ones from the State Assembly and all that, when they are supposed, the Court of Appeal is supposed to have made pronouncements on issues affecting the society and taking into consideration what the people wanted. The Court of Appeal made, well, I don't want to say a wrong decision. The Court of Appeal made its own gave its own judgment based on maybe what they perceive as the correct position of the law. And an unfortunate situation is that you cannot appeal to the Supreme Court because that is the end of the matter there. But even if the people are aggrieved, yes, the people are aggrieved because from the decision of the Supreme Court, it can even be seen that that judgment was wrong in the first place. It was anchored on the same primaries. And so it is not possible for somebody to now say that the primaries that produce the governor, which has been affirmed to be correct and without any disobedience to court order, has been affirmed by the Supreme Court. And that same primary is what is keeping the members of the House of Assembly said to destabilize the members of the House of Assembly are not said to be proper. Said they have no structure because they made the election was based on a wrong primary without complying with the court order. So it's rather an unfortunate situation. You go to the NJC. The NJC does not have the power to upturn the decision of the court. What the NJC can do is to punish. That is the unfortunate situation. The NJC can punish, and then until the law is amended, so that although I don't even canvass that the law should be amended for all the cases to reach the Supreme Court. No, because of the congestion, because of the time frame. But one thing I keep canvassing is that all the cases should be concluded before the parties are sworn in. The cases should be concluded from the tribunal to the last court. So before the candidates are sworn in. If these are done, you will see different pronouncements in respect of the cases, even including the presidential elections. But Once there is an incumbent, once the person that was said to have won, whether by move or crime, enters, is sworn in, it becomes difficult for the court to upturn, to upset the system, because that is going to affect a lot of things. How do you, the Constitution has now made provision for what will happen in a situation that there is no president, that the court will say there is no president. So what will happen?
Thank you for your thoughts. Let's get to Jide Ojo. Once again, you followed what's developing regarding this story. And of course, the law provides no remedy for this particular case. What are your thoughts on this?
I think we need to alter the Constitution further. Don't forget that up until 2010, before the 2011 general elections, the Court of Appeal is the last court for hearing and determination of governorship election in Nigeria. Many people don't know. The dynamics changed after the alteration of Constitution in 2010, and since 2011, the decision on the governorship election now terminates at the Supreme Court. And that's what has come Andy or Kele Muftwang, Kabiru Yusuf of Kano, and Lawa Dauda of Zamfara State. We do not know what the Supreme Court decision will be in terms of Nasarawa governorship election petition when the decision, when the judgment is given next tomorrow. But suffice to say that sometimes this happens. This is life. May we just not be unfortunate. The development Amena, you need to understand, even for medical practice, sometimes the best of doctors make mistakes where life is lost. Doctors that are very good and yet very careless, it may not even be the doctor itself, but it may be the nurses, it may be the anesthetic, it may be the laboratory lab people that will just give a wrong diagnosis.
Barrister Mike, as a legal practitioner, what about the judges? You talked about punishment. Are they just going to continue judging cases without any form of checks or balances? What should be done in cases like this?
You see, the only thing that can be done is to punish the judges. That is the only thing. And the people have taken the right step by going to agency. But the decision cannot be offset. The decision of the court cannot be offset. That is the challenge. And so what they need to do is to prepare for whatever election that is going to be done, to ensure that the right thing is done. And then also to ensure that subsequently, when there is an issue like that, it is resolved. Recollect what happened in Bayelsa State some time ago when APC actually won the election, but the unfortunate thing was that the deputy governor was not qualified in the first place. They are using of the name and all manner of things. And so, but this was brought up, this issue was brought up earlier, and they swept it under carpet and ignored what the people were talking about until when it got to the tribunal, that the tribunal said, the Supreme Court had to set aside that judgment. And that was too bad. So, they set aside that election victory, which was too bad. And they learned their lesson. And once the next one, there was they raised the issue of some disqualification, which they immediately ensured that it was corrected before they went on. So once there are issues like this, what they tend to do is to ensure that lessons are learned, and then corrections are made, and then we move on. We move on. The players, those who cause the pain and all that, can only be punished in the situation.
Barrister Umuna, I would love to ask you this question, even though the answer is pretty obvious. We've been following the conversation regarding the victory of those who came into power due to the sacking of the 11 lawmakers in Plateau State. And some circles are calling for those particular lawmakers to resign their positions so that those who were sacked by the Court of Appeal, could come in and resume power. What do you make of this?
In this country, I can never see that happen. I can't see it happen in this country. If somebody can canvas a situation, but it would never happen that the court gave victory to you and you say, well, I know very well that I did not win. I did not even do anything about it. The contest was not between me and you now say, I want to resign based on morality, based on my conscience, because I know I was not the one that was elected. It's not done in this country. People, that is you are talking of a situation that is supposed to be. You understand? That is the right thing that should have been done in any climb that respects morality, that respects the rule of law, that respects conscience. But you see, we have dead consciences in this country. So many people cannot even think of doing the right thing any longer. And that is why it is possible for somebody to cook up documents to ensure that money is siphoned from somewhere into private account without any conscience. So people are no longer having good conscience to be able to do the right thing. In a situation that is supposed to be straightforward, this is what your suggestion is what is supposed to be. But you can't have it in Nigeria. You can't have it even if somebody that did not contest election at all is given the mandate to come and govern because the other party is disenfranchised or the election is nullified. He will step in and start making noise about how is God has made him a chosen one among others and all manner of things. It's such a difficult situation that somebody will say because nobody will want to abandon his what do I call it gift now. Somebody is a gift that somebody has given to you. You say you want to abandon it because you feel that your brother or the other person was the one that rightly deserved.
Many praised the non-interference of President Tinubu in the process. Some of the governors, earlier were talking about the fact that they could not sleep. They were having restless nights. Even a particular governor had to come to Abuja all the time just to ensure that his opposition did not influence the decision of the Supreme Court. What do you make of this? And what's the likelihood of a sitting president in terms of his ability to be able to influence the decision of the Supreme Court? And how did it play out regarding these particular cases?
Well, I would not say that it is the president that influenced the decision of the Supreme Court. Granted that the president or the head of the executive being all powerful can influence the decision of the courts. I don't want to believe that he actually, this present president, influenced the decision of the Supreme Court. The reason is this. When you look at the case of the Lagos State in particular, you will discover that the case was not very solid, so to say, from the tribunal. It was not very solid. And we saw the loopholes here and there, and we knew that it would be practically difficult for somebody to upturn or to nullify the election of Governor Sanwo-Olu of the APC. when they took the court, I mean the tribunal decided on the issue, I expected the respondents, that is Labour Party, PDP, just take it and forget about going on appeal. Because if you go through the judgment, you discover that they did justice to the entire judgment. And they continued to the Court of Appeal. It was dismissed. They went to the Supreme Court. In the Supreme Court, it was just going to be, how do I put it, a walkover, because the Supreme Court would hardly in a situation that the sitting governor had been affirmed by the tribunal and the Court of Appeal, would hardly upturn it. It would hardly upturn it. It's very rare. Now, as I told you, bearing in mind the policy aspect of the Supreme Court, the reason that the other ones that were actually upturned by the tribunal and the Court of Appeal were affirmed was because the Supreme Court did not want to, apart from the law, because the law is also there to guide, the Supreme Court did not want to upset the system. I've said that for now. So it's not that the president influenced the judgment of the Supreme Court. It might have happened, but you see, the judges are not robots. They look at things objectively. Even if somebody speaks to a judge that I want you to make this judgment to go this way, the judge will look at it. What will be the reaction of the society when it comes to the perception or reception of the judgment? These are some of the things that the judge will look at before acceding to a particular request to influence judgment. The Court of Appeal decision in Kano State was a very funny one, because we discovered that the judgment, the certified true copy of the judgment, was saying several different things from what was pronounced in the court. And the main judgment itself was saying a different thing, the conclusion was saying a different thing. And there's no way the Supreme Court would have upheld that decision, because it tends to show that there were influences on the members of that court that gave the judgment. That is the thing. But you see, when the judgment of the Supreme Court is delivered, you look, I have not read the judgment of the Supreme Court yet, but when they are delivered, you look at so many issues, take so many factors into consideration before you now think, by the time you look at it and you don't flow with the flow of thoughts of his lordships, then you can now say, well, I believe that this judgment was in place. But from standing from outside, as it were now, and looking at the way the judgment flowed, I would not believe that the president influenced the judgment.
Barrister Mike Umunan, as a legal practitioner, I wanted to ask you, given the verdict from the Supreme Court, most especially in Kano and in Plateau states, they made mockery of the judgments from the appeal court. Is the judiciary divided, and why are they at loggerheads with the decision of the appeal court? Does this make any sense at all? Do you find this amusing?
My brother, that is another aspect that I do not buy into, what the Supreme Court, the way the Supreme Court castigated the Court of Appeal and some of the decisions. I do not buy into that, because no matter what happens, the judiciary is supposed to be one. And if the Supreme Court, in its wisdom, discovers that the Court of Appeal judges erred, maybe by reason of thinking that they were swayed they were or maybe persuaded by some external factors and all, you don't need to state that in your judgment. You don't need to castigate them. You don't need to start lambasting them, and in the process making even the judges themselves that gave the judgment in the court of appeal to look to dampen their spirit. And then the people will now look at them as people who do not know the law, who do not know what they are doing, who are bribery prone, and all these things that people think about. So it's an unfortunate situation that this happened. Instead of that, the Supreme Court can always make recommendation to the agency that these people should be punished. They should be punished. In fact, it's not just, it shouldn't end in telling the world that these people did that. Because even as a judge, when you misapply the law, you are causing serious injustice to the system, and so you are liable to be punished by agency. It's not only the issue of saying that you collected bribe. When you misapply the law, as it were, you know what the law is, and you misapply it, you are supposed to be removed. You are supposed to be punished by the agency. So it's not that an issue of saying lambasting them in judgment and saying they shouldn't have done this, they shouldn't have done that. What step have or steps have you taken to say, okay, these people did this, they should be punished for doing that, instead of just saying that they did not do the right thing, they did wrong thing, and because of that, people suffer. That no, it shouldn't end there. There should be proper ways of ensuring that these people that cause this problem suffer for it, because people have suffered by reason of their problems. That is one. Two is that the judgment of the Supreme Court tend to show that no matter what happens, if you are able to win election, if INEC is able to declare you elected, then you can go to sleep, because the Supreme Court will tell whosoever is contesting it against you that it doesn't have any case, and the case will be dismissed, barring all the other legal issues that are advanced. You understand?
And Barrister Umunan, my final question for you today on the show. What are some of the take-home lessons from these court cases that we have witnessed? And this appears to be, the final batch of the election petition cases. What are some of the lessons for INEC, for the judiciary, and for legislators, who the onus rests on to actually move for for a review of the Electoral Act?
First of all, I want to say that the judiciary has not done its duty very well in respect of reprimanding or punishing those who are supposed to be punished by way of by reason of the infraction that occurred during the 2023 elections. You see, INEC misbehaved squarely, and everybody saw it. It seems as if the judiciary is now giving a stamp on what the illegalities that INEC did. It's an unfortunate situation. And I want to believe that subsequently it should not be allowed to go that way. One, there's the legislature. I know that some of the members of the legislature, as it is now, are beneficiaries of this unfortunate situation. But the electoral laws should be amended once again to ensure that some of these loopholes are plugged. Some of these areas that have controversies are changed, so that we don't continue to go to court. We don't finish election and they will tell you go to court. And when you go to court, you discover that there's nothing that the court can offer you. We need to reflect what the position that the people want. And another thing is that there are some of the electoral or a part of the constitution that are very straightforward, which the court has given very ambiguous interpretation, like the issue of the FCT having a special status by reason of what the constitution says. So that part of the constitution should also be amended to ensure that this is exactly what we want to happen to FCT. Not that somebody will think it is this way by reason of what the constitution says, and the court will say, no, it cannot be that way, it is this way. And in the process, you put the people in a difficult situation. There are certain things that could have been decided straightforward without any issue. But because of the way the law is couched, and because of the way the interpretation is made by the judges, by the court, it becomes difficult to bring out justice from that system, from that situation. And that is why I believe that if the judiciary does not also clean up the system, clean up itself, so that only those who are properly minded, who have the mindset to be able to do justice, are allowed to sit over electoral matters. If the elections, the electoral laws are not amended to reflect a position that the court will pronounce and the people's will be done, if nothing is done about the umpire INEC itself as it is presently constituted, I can assure you that subsequent elections would be very, very terrible. This country might not exist to witness another election if the position of the law remains as it is, if the judiciary remains the way it is, because so many people have lost confidence in the judiciary. Forget about what the governors have said, those who have won in this Supreme Court decision, that we still see that the Supreme Court is the last hope of the common man, and all manner, the court is the last hope of the common man. It's because it has favored them. Those who are not favored grumble and say justice has not been served, justice has not been done. You understand? So the moment we are able to put things in place, then when we want to have election, everybody will know that if this election, if we fail, and there's no need to go to court.
Jide Ojo, thank you so much, public affairs analyst, for being with us on Politics Now, and also Barrister Michael Munan, who joined us from Lagos. Thank you so much for your thoughts on this particular edition of Politics Now. And this is the much we can take. We have to draw the curtain right now. My name is Morno Balagogo. Thank you for watching.